The floor is yours. Michel CANNARASA, you are Dean at Lyon Catholic University in the law school, and you have also specific interest in, I would say, in law academic, in European Union law and comparative law. So I think you have many things to say about legal perspective on smart contracts.
Thank you very much. Thank you to the organizers, of course, for inviting me. And as you can see, I wear a tie. I might be the only one in the room. But this is one of the nice aspects of interdisciplinarity is that lawyers, but there are other lawyers here, I know, but still, in terms of cultural differences, what is casual chic for a lawyer might be different. I don't know. This is another topic. So this will be a presentation, rather, I would say, a traditional presentation from a legal perspective. I'm a legal academic, not much involved in practice, even if I try to understand as much as possible the technology behind smart contracts and the actual applications or the various trends. And as you will see, at the end, there are more questions than answers at the moment, but this is in part the beauty of the topic, I think. So just some reminders, but I think everyone in the room is quite aware of what is the general context of blockchain and smart contracts. So we are, of course, in a digital environment. Smart contracts are computer programs recorded onto a blockchain. The agreement is based on codes which are able to enforce and execute themselves. And the codes are dry codes and not wet codes, but we will come back to this difference. One of the main features, as far as I can understand, of smart contracts is that they can execute themselves. Not necessarily being formed on a computer protocol, but at least the performance, the execution side can be automated, which is quite new in the contract world. One distinction might be worth mentioning is the distinction between deterministic smart contracts and non-deterministic smart contracts. So the first, it's based on the question whether the network has sufficient information or not to determine an outcome without need of outside information. So if there is no need of outside information, it's a deterministic smart contract. If not, it's non-deterministic. And if you need outside information, you need an oracle. An oracle that will interpret external feeds and will come into play and feed this information into the system. The oracle can be a device or possibly a natural person. So the main features based on this broad description is that in theory you don't need intermediaries, and as you know, this is the assumption of the blockchain's purists. You don't need lawyers, courts, law enforcement agencies, banks, insurance companies, state, or whatever. You don't need trust. You don't need to rely on your contractor because the security is provided by the system. The blockchain will require, and it was mentioned this morning by Mr. Garapon, and this is, from my point of view, one of the most interesting questions for a lawyer, is that we are talking about a virtual world, but there will be a connection, an interface with reality at a certain point. And according to me, this is when the connection, the interface with reality occurs, that blockchain or smart contracts become legal. Before that, there is not necessarily a need to apply legal categories and legal frameworks on what is happening. But when you have this connection with the real world, and this is where the complexity lies, according to me, you would, you apply your legal approach and mindset and categories. So in a smart contract, contractual terms will correspond to computer codes. It can be quite simple. When the payment is confirmed, ship the product. So this is a classical contractual term, and it can be coded quite easily and performed automatically by the program. So what smart contracts can do is that they can trigger performance of the contract. They can potentially control physical movement of goods or money. You can split contracts, and this is what is happening at the moment, as far as I know, and this is probably the most interesting trend at the moment as well, is that formation of contract can be based on the traditional approach, but at a certain point you will have a part of the contract that is coded and performed automatically on the basis of the blockchain protocol. So splitting contract between the analog or traditional contract and the smart contract is an approach at the moment, and is probably the most promising, at least in the medium term. Smart contracts works well in the Internet of Things, and I think what you described is in part this word of Internet of Things. And as far as I know, there are big car producers, I guess in France, but as far as I know in Germany, that run a part of the supply chain on the basis of electronic devices, ordering spare parts when they are missing, and another device will send the order, the payment is done electronically, and so on. So for that kind of contract, and when you rely on the Internet of Things, you can make things much more efficient based on smart contracts. Some differences with our traditional and beloved legal contracts. So legal contracts or traditional contracts are based and written in human language, the wet language, whereas smart contracts are written in computer language, so the dry code. One of the consequences of this difference is that interpretation, which is central to traditional contract and done by courts most of the times, is in theory not required and possibly not possible when you rely on a dry code, so on computer code. Smart contracts are in theory inflexible and unable to adapt to changing circumstances. It doesn't mean that it's not possible at all, but from what I see, it's not the concept at the moment. You cannot have broad and general rules like good faith, and this is one other interesting question, especially for continental lawyers like French lawyers. These broad principles which we tend to rely on are very difficult to code. Imagine good faith. It's not yes or no, it's in the middle or possibly. Let's, concerning the 3 points I wanted to touch, formation, performance, and interpretation. So formation of contract. Technology cannot negotiate the terms, but can automate the execution. This is the main example at the moment. But we can consider that smart contracts programs could verify certain conditions in order to activate the acceptance of an offer. And in that case, you have the process of formation of contract based on the computer, the protocol, the computer code. A human input at the moment, at least, seems necessary at the beginning of the formation process. Is coding comparable to legal drafting? My answer would be no. So it raises questions for attorneys, practicing lawyers who are drafting contracts, because more and more they will need the help of a developer, of a computer person, because lawyers are not in capacity. There are some exceptions to draft a smart contract. then what will be the status of the computer program? Is it an agent working for the two parties? The agent has not a legal personality at the moment because it's a computer program. These are further questions, very interesting. Performance is it's the core of smart contracts. In theory, this is what smart contracts are very interesting for, is that they can allow an automated performance execution of the contract with some information coming from the outside, from oracles, but apparently it's not possible to stop the performance of the smart contracts once it is triggered. So the courts, for example, could not stop the performance, or you have to think about a system to allow judges to stop the performance of the contract, or the parties possibly, but it's in contradiction with the blockchain idea. What happens when the formation of the contract was not done properly, when you have a mistake because you didn't understand the computer language, when you have a fraud and so on? In real world, you can avoid the contract, but is it possible in a smart contract world? At the moment, quite sophisticated contracts are not well suited for self-enforcing smart contracts. This is why splitting the contract could be an interesting approach at the moment, at least. What about remedies when something goes wrong? In theory, if the contract is self-enforceable, you cannot have a breach, and if you don't have a breach, you don't have remedies. You don't need remedies. And in any case, it would be hard to apply traditional remedies to smart contracts, damages, termination, specific performance, even if I think that this is something conceivable to have damages. It was mentioned, I think, in the previous presentation. Termination of the contract, I guess that you can code this. I'm not a computer person at all, but I rely on the expertise. Specific performance as well, but you could think about self-contained remedies into the contract, and this is very interesting because you don't need to go to the court, you don't need to wait for the court to decide, so it's very cost efficient. Interpretation, natural language requires interpretation, computer code not, and possibly doesn't leave room for interpretation. This is quite interesting, I think. And from a comparative law approach, it could even have an influence on the civil law legal system, the continental legal system, because our legal categories, our drafting styles and so on are quite different from the common law approach. And I think that smart contracts and smart contracts approach are more compatible with the common law approach rather than the civil law approach. Common lawyers and common lawyers who draft contracts tend to write very sophisticated contracts in order to foresee everything and in order to prevent the courts to come and say, this is what you had the intention to put in the contract, even if it's not the case. Civil lawyers tend to rely and have to rely on the intervention of courts. So using more and more smart contracts, I think, could have an influence on the structure of our legal system. But this is, another point. We could think about fixing interpretation rules in the smart contract in order to prevent outside intervention, especially by courts. So all these questions raise challenges and interesting challenges. We mentioned some of them earlier. So what will be the impact on private law and on legal categories, especially in the civil law legal system? What is the applicable law? This is probably one of the crucial questions. How to deal with consumer protection? In theory, smart contracts could provide more efficiency in terms of consumer protection, I think, and you can personalize consumer protection. It can be good or bad. What happens if the code is defective? What about taxation, crime? We mentioned the regulatory challenges. Well, should we apply our existing legal system? Many lawyers think that at the moment we don't need to revolution in legal categories and so on, because we can go quite far with our existing legal systems. But things move fast, and if the regulator doesn't catch what is happening, and as you know, the technology is shaping the world, the real world, and technology is shaping the legal world. And I don't know if we are able to catch up, but still, if we don't do something, and if we don't understand what is happening, there is a risk of exiting the legal system. A risk from a certain point of view. For some people, it might not be a risk, but something desirable. How about translating into human languages computer codes in order to give the courts the opportunity to, well, interpret contracts and rule on specific cases? How to reverse a smart contract exposed, and so on and so on. So, well, again, it's a very initial step in the reflection, but again, the main message is that, and fortunately enough, more and more people are doing so, I think. Lawyers have to, well, understand, work with computer scientists, with economists and so on, because this is, well, the first condition probably to, well, to save lawyers, or to do our job in order to make the evolution as smooth as possible, and that's it.
Thank you very much. Maybe one first question. Florence raised the issue of UNCIT role and what would we need as a regulation, etc. You spoke about the risks for legal systems, etc. And where do you think it would be the most efficient to get some new regulation or legislation or even normalization?
Well, I think probably one of the soft rules are interesting indeed, but it's a contractual approach, and if you want a true regulatory approach, then you have to look at the legislator. So from my perspective at the moment, the European Union stage will be the most interesting from a French and European perspective, of course, for several reasons. One of the reasons is that at the moment you will see a fragmentation of the internal market, because if the French legislator enacts some rules about bitcoins, and if Germany does, and this is what is happening, then you have a huge risk of fragmentation. From what I know, the European Commission has launched several projects in order to see what is happening and see if there is a need for regulation. So my belief would be that the central regulator, but then you don't have, it's not anymore a true blockchain, it's a regulated blockchain. Otherwise, yeah. Well, I know that there are many private initiatives in order to apply the protocol in many different issues, and they are very interesting. But then it's like having many private legal systems. So some might think that it's good, others, but you know, lawyers tend to love written, especially on the continent. You know, written rules, clear rules, and so on.
Are there some questions?
It seems like the transition from either the legal or the common law system, which has been enforced in some way or another is a transition from encoding rules and agreements into words. Words by their very, very nature are unspecific and ambiguous. And the transition that we're proposing to make here is from word-based communication and agreement to Boolean logic-based communication agreement. Insofar as you generally accept that Boolean logic is very, very simple, extremely clear, and lends itself very well to coding, doesn't the sort of the interstitial or intermediate problem become one of how do you tie certain concepts that are too complex and diffuse to be approached, such as the notion of privacy or the notion of good faith, like you mentioned, and have a link in between these very, very well-established but non-Boolean expressible. Good faith you cannot express in Boolean terms. How do you draw, is anybody trying to draw a link in between applications that tie in these traditional legal notions with Boolean tools?
I'm not aware of that, but I don't know if it would be possible at all. But maybe because I'm not a computer person, I don't know. But when you have to, to have the yes/no approach, or if then, to describe good faith, for example, it will require many lines, which is not necessarily bad. But when I mentioned the difference between common law and civil law, is that the point is that you can have 100 pages or even more common law contract. That is not impossible, far from it, because there is already this approach, if then. This is not the traditional approach in civil law legal tradition, fraud, mistake, duress, good faith, breach, fundamental breach, and so on. At the moment, it seems to me very far from the computer language. So I'm not aware of people trying to translate, let's say, or to bring to close the gap. And frankly, I'm not sure that it will be possible on the basis of the existing these existing legal concepts and their definitions. But it's probably. I don't know, but when you have the sophisticated legal system, I think the gap is shorter between natural language, human language, and computer code. The less the legal system is sophisticated, the bigger the gap is. But I don't know.
I have a question that. I have a question that is directly related. It's possible to write in 0-1 in the program, but the events that happen in the real world are not themselves 0-1. If I write a contract that says, if you give me the money, then I will ship you the good. Well, when it comes to actually shipping the good, lots of things can happen that are not in 0-1. I can ship it quickly or not. I can ship it in good condition or not. I can ship this type of good or another type. And if we have to write all these contingencies in the contract, it might be.
I would be happy to address specifically your question with regards to maritime law
Mm-hmm.
and terms of shipment, because there's something called Incoterms already. It's a longer conversation, but if there are existing Incoterms that define where something is picked up, where the liability ends, there are shipping delays, billing delays, and all these can be measured. And as one of the previous speakers said, utilizing Internet of Things devices, the IoT devices, we can know very, very clearly whether a container has arrived on time, has left on time, has been properly handled, whether the customs papers have been properly filled out, all these things. So maritime law and shipping goods is interesting. Earlier on, the professor mentioned something interesting, that was that there are currently companies, for example, that are shipping in Germany, but also globally by now, goods when parts are needed. This is not currently done using blockchain. It will be at some point in time. It's currently done using EDI. And the problem with EDI is that it is very expensive, imprecise, and requires point-to-point communications. So right now, when Brembo sells brakes to BMW, they probably don't make an order for the little goupille or whatever that goes through. They order them with this process. It's not a legal process. It's a common business arrangement that is backed up behind it by traditional wet contracts, as you would call them. But if you're happy to discuss afterwards.
Yeah, the maritime and sea shipping is the sector where the blockchain technology is developing a lot, because you can have time of departure, temperature of the goods, quality, color, and so on, possibly with oracles that can be real persons or devices. Yeah.
One last question.
Okay. There was a field in expert systems some decades ago, which was called fuzzy logic, which instead of considering only false, which is 0, and true, which is 1, considering all the intermediate values. And then an and on an or would be translated in plus or multiplied or any kind of function, which more mimics the natural reasoning of humans to go to a decision. And when a decision has to be made, then it's just a matter of threshold between what's under or over a certain value. It solves many natural life problems to think like that.
Thank you. Do you want to?
It was a question or?
It was a solution.
A solution, yeah. No, well, I think that ideally we would like, our decisions to be governed by very clear rules and applied on a systematic basis. At least this is a default of lawyers or some lawyers, but it doesn't happen in real life, but not necessarily for good reasons.
Thank you very much. I think unfortunately, we need some time for the next speakers.